going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Happy Sunday. Happy Easter Sunday. Got a tough case for you. Judge Middleton, this defendant is pleading, I think, no contest to, I don't remember what level of crime it is, some sort of embezzlement or stealing from Pivotal, which is a mental health organization in St. Joseph County. It's a tough one, especially for Judge Middleton. He sends a lot of people to Pivotal for, any kind of, they need mental health help. Sends them there. And we have someone that works there who, you'll find out. Before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
10:30 is another larceny type case with some complicated issues. I really wish I had a prosecutor here, but I don't. The next matter is People versus Mariela Contreras Barajas. File number is 232349 FY. Ms. Barajas is here also wearing a mask with her lawyer, Kiana Garrity. Good morning, Ms. Garrity.
Good morning, Your Honor.
This matter was charged kind of oddly, I guess. I'm not being critical, it's just odd. They charged with improper medical records, placing false information on a medical chart, several counts of that. Medicaid fraud claim, several counts of that. Those were all felonies. The defendant actually entered a plea, I believe it was by no contest, to embezzlement over 200 but less than 1,000. She was an employee at Pivotal. The allegation is that she falsified her records, resulting in payment she was not entitled to, and placing false information in clients' records. As I indicated, I wish I had input from the prosecutor. I do have a letter from Jarrett Cupp, the Chief Compliance Officer of Pivotal, dated February 22nd of 2024. Do you have that, Ms. Garrity?
No, Your Honor, I do not.
You don't?
No, I did receive the short sentencing memorandum from the prosecutor that was emailed to me.
Well, all right, let me look at this because you should have it. We'll take this one. Let me see where I got it. It's put in the file. And I did get a sentencing memorandum. She must have just filed that. I didn't see it on Friday. Basically, just saying, use your discretion. I'm going to put the conference room in the waiting room. Somebody's not very happy to be here at the courthouse. Yes, it's spring break. Here we are.
Yeah, you would be in daycare right now.
All right, well, we'll get to that here in a minute. Those are set for 11. We're still working on our 10:30 cases.
Do you guys remember the video I put out a few days ago where the defendant in Judge Boyd's courtroom said that his three-week-old son asked to come to court. He wanted to come. He asked to come to court. He's 3 weeks old. That flashback just went through my head when that kid was crying. He asked to come. He really did. He wanted to.
I apologize, Ms. Garrity. That letter should have been provided to you. It was in my file. I don't,
Your Honor, they may have sent it to my office and it's probably still in the mail, perhaps if it was Friday, but,
no, I got that on February 22nd.
oh, okay.
Marissa's message was just today, I think. But anyway, they've given some input. She raises a number of the issues that I had raised. No correspondence was received addressing any remorse on defendant's behalf. You can have that.
Oh, okay, thank you.
So this is a 1-year misdemeanor like the last case. What would you like me to know?
Your Honor, first of all, we did plead no contest. So for the
Yes.
prosecutors to expect a letter like that is inappropriate. Obviously, she cannot write a letter to anyone discussing the matters. We did plead no contest.
Yes.
I can't elaborate and speak on this case, Your Honor.
Well, it's not inappropriate. It's allowed under the Crime Victims' Rights Act. And
Not if they're threatening you with civil action potentially, or you're looking at something potentially with the Attorney General's office, as they originally filed this as Medicaid. So,
yes, well, I don't know. I think this would resolve that. And no contest concerns me because you don't accept responsibility. You accept the conviction without accepting responsibility. As you can tell, Pivotal is quite concerned about this, and a defendant has a right to plead no contest if the prosecutor accepts it. Now, if you could plea on the nose, if you're charged with breaking and entering, and you wish to plead no contest and enter a plea as charged, there's nothing I can do or the prosecutor can do about it. You have a right to do that. But if the charge is reduced, as this was, from felonies to 1 misdemeanor, I have to have the prosecutor's consent for it to be by no contest. Now, we talked about this at the time of the plea. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. So that's what's happened here. And you're right, it puts you in a difficult spot. For example, let's say you pled no contest to domestic assault, and your partner wrote a letter saying all the terrible things you did. Well, then by pleading no contest, you can't get up and say, well, no, I didn't. And so it puts you in a difficult position. Particularly what I'm looking for as the last lady is some sort of contrition or acceptance of responsibility or remorse. And I'm getting not much vibe for any of that. And so I'm not sure where we're headed here, but Ms. Garrity, I'm sorry, I cut you off, but go ahead.
If I may elaborate, Your Honor, usually I know the court did go with the affidavit of probable cause. Usually I actually sit down with the prosecutor, look at the sections that comport with the plea for which my client's going to do, and then I say the facts of that. So having spent time with Ms. Contreras, and I would like to add, Your Honor, I know the court said you were looking for some contrition. I can tell you firsthand, having handled embezzlement cases and running preliminary examinations with patients, it's very difficult, it's very tiresome, and it's very stressful because they would have to come in, account for those days. People's recollection are very poor, very bad, and most of it may have not even passed probable cause. I've seen this happen. In this case, Your Honor, she was working under a limited license, which means that after everything that was done, every time card was to be approved by the supervisor, checked by the supervisor, and then with that, then go to billing. I don't believe that was done, or perhaps I'm not sure what happened. because there are redundancy plans in place with these facilities, whether they're private, public, or nonprofit.
All right. This defense attorney has taken a page out of, was it Mr. Reagan? It's Reagan, right? Yeah. I was thinking Reagan or Bird. Bird's the Reagan 2.0 or Reagan Jr. She's victim blaming. I don't want to get too much into this right now because they haven't said what she did yet. So I don't want to jump ahead. But remember this. This defense attorney is saying it's not all of my client's fault. It's part on Pivotal. Pivotal was responsible for, A, B, and C. They didn't do that, and they allowed my client to get away with this for too long. Come on. Come on. Come on, Judge Middleton. Get back at this. Come back. Something. A speech. Something.
So there was some sort of issue there. Even Ms. Contreras does not recall specifically all these clients, the hours, or anything of that nature. But she has acknowledged, obviously, and we have taken responsibility for an amount between 200 and 1,000, with actually agreeing to pay all the restitution without having gone through a restitution hearing or going through a preliminary examination to go through every single accounting and every single witness testifying to account for that, Your Honor. So in my personal belief and experience, I think that does show a lot of care and concern for people involved for prolonging this for the hours of, as the Mr. Cupp has elaborated on, the compliance officer, the time taken away from this. And so obviously my recommendation and my counsel to Ms. Contreras is to make this as quick as possible, to not prolong it, to, in a sense, mitigate what you can, and to keep working to make money to pay this restitution off in full as soon as possible. So that's what we're here prepared to do, Your Honor. Obviously, we do not have a sentencing agreement with the government or this court, and Ms. Contreras is prepared to do whatever the court deems fit. But that is where we're at, Your Honor, and we are prepared today to do just that.
Ooh, that long stare. Come on, Judge Middleton. I know you got something up your sleeve.
The prosecutor's position, and they did file a memorandum. What one time happened is they would just send an email, and we said, please stop doing that. If you're going to do something, file it as a memorandum. So Melissa's been doing that, which I do appreciate. Defendant embezzled $6,428.71 through her employer CMH. To our knowledge, the defendant may also lose her license to practice in her area of work, counseling patients. And I don't know about that. That goes under the category of extrajudicial sanction. Defendant has engaged in extremely deceptive behavior and has made no attempt to begin to pay back this large amount of money. I'm not critical about that because you got counsel, and I'm sure your lawyer said don't do anything until we resolve this. So the fact that you haven't paid it back doesn't offend me. The defendant has received the benefit of retained counsel, but no correspondence was received addressing any remorse on the defendant's behalf or steps being taken to make this right. The people request that the court sentence the defendant pursuant to the laws of the state of Michigan. The letter from Pivotal which was dated February 22nd. I'm not sure at what point I saw it. Maybe the first time I saw it was.
Just a heads up. This happened this past week. I don't know. I think it was Tuesday, possibly. So this isn't terribly old. So Tuesday would have been the 26th. It may have happened on Wednesday, the 27th. I don't really remember. It was early this week, though. So I didn't take this from a month ago.
Friday. Mariella, who was a licensed master social worker and key provider within our organization, proved that she was not. Particularly in our organization, time card fraud has a cascading adverse impact on Pivotal and those it serves. When this fraud came to light, I and others in the organization were forced to audit every client file to ensure their integrity and, more importantly, to ensure that our clients were receiving the services they needed. Our investigation, which began September 13th, revealed the following. Despite reporting hours worked on her time cards, we discovered this defendant had not so much as even met with 13 of her assigned clients, consisting of families and children for several months. One such client had not been seen for over 8 months. When confronted about these omissions on September 15th, Mariella refused to meet with her supervisors. Instead, the next day, she placed falsified progress notes dated September 16th in the agency records of 3 clients. If I had not discovered these and audited the rest of her assigned files to remove false information and verify the remaining case notes, fraudulent records remaining in the client charts could have led to improper care and treatment directives that could have significantly harmed these families, and claims of noncompliance or neglect if the client was the subject of a court proceeding. The defendant fraudulently reported working 190.5 hours, or approximately 1 month of time, and worked none of those hours. These falsified time cards caused her to be overpaid $6,579.87 by the agency. While the overpayment resulting from Mariella's time card theft can be calculated, the additional costs incurred by Pivotal to investigate and unwind the related cover-up and protect the clients is not easily quantified. Pivotal expended, and even today continues to spend, considerable time and effort in investigation and corrective measures, including other things, which were costs. As the chief compliance officer, I led the investigation, spent countless hours reviewing files, interviewing staff and clients, taking corrective measures, and cooperating with the prosecutor. In the final sentence, Pivotal and the citizens of St. Joseph County have been betrayed. It is requested at a minimum that Mariella reimburse Pivotal for the full paycheck amount of $6,579.87 for the time that she falsified.
All right. So for everyone who skips through my intro, I understand that. But Pivotal is a mental health organization in St. Joseph County, and there are people that are court ordered to go get some mental help, and Pivotal is where they send them. So essentially what this defendant has done is she said she was working and she wasn't. So not only do you get the court ordered people that aren't getting their court ordered treatment, which, you know, the court order people might be happy about that. Oh, she's not showing up, then I don't have to go, and she's still signing these papers. Yeah, they might be happy about that, even though they might need help. But then you have the masses of people that go there who actually go there for help and aren't getting their help. This is terrible. And I will say that Judge Middleton is generally softer on a lot of defendants than I think he should be. And a lot of you think that too. I see it every time I play a Judge Middleton video. I really do wish I saw him a little bit more angry in this clip. He's very angry that she's not taking responsibility and pleading no contest. I don't know why the prosecutor allowed her to do that. I really don't. Maybe because they let go of Debbie Davis. All right, that's all I'm going to say about that. All right, let's keep going.
As in the last case, this didn't just happen once. It was a pattern of dishonesty and misbehavior, which embezzlements often are. This is a no contest plea. I'm gonna do similar to what I did in the last case, 12-month probation. Embezzler treatment group. One problem, the embezzler group is confidential. And so you can be forthcoming about things. I don't know if there are other things coming, like licensing sanctions or those sorts of things, but as far as criminal prosecution stands, I think this is it. I believe you spent 1 day in jail. I'm gonna order 31 days in jail. You're gonna do 30 days like the last lady. Credit 1, leaving 30 days to serve. Do you want to do it now, or would you rather it be scheduled?
I have children, so I would have to.
Yeah, I don't agree with this. You're going into sentencing. Your defense attorney has already said that there's a possibility of jail time. Your kids should be taken care of right now. They should. Judge Middleton, I disagree with this. He did it with the last one too. The last case. I played the last case earlier in the week and did the exact same thing. A sentence for 30 days and then let them schedule their jail time around their schedule. No, I don't agree with that at all. Send her to jail right now. Do her 30 days. Get out. Start paying this company back. Like, what happens if this, that was the breaking point of Pivotal and all of a sudden they go under because of this? 190 hours in a month. So that's 30 hours of overtime, and she didn't work anything. And then she tried to cover it up by writing false notes on clients' or I don't know, paperwork. Something massively could have gone wrong here. Just lucky no one was injured. Like, no one that needed help didn't get it and did something because they weren't getting the treatment they needed. She is very lucky, and that's why I agree. That's why I'm saying, like, I really wish I saw Judge Middleton in this particular hearing just show a little emotion, get angry. And I understand why you can't, or why you shouldn't. But all right, I'm gonna let this play out. You guys are all awesome. I will have another video in a couple of hours as a premiere, and then we're gonna go live tonight. All right, until next time. Bye.
All right, same consideration. I thought about more, but unlike the last lady, you have no criminal record. We'll have the probation department arrange the jail time. Once again, the fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee. Restitution is $6,580 to Pivotal. Probation oversight is $480, and you're to pay for the class. $7,335. That's a lot. There's no bond. It was a PR bond. That's due in 1 year. If we need more time, we can do that. Again, I don't believe drugs or alcohol are a problem here, but everybody has that as a condition of their probation. I'm not ordering any community service. There's a lot of restitution to be paid, and there's a jail component. When you plead no contest, I don't even get a "I'm sorry." All I get is they didn't calculate this right. And I didn't steal that much. But you agreed on this amount. I started the embezzlement treatment program when I was prosecutor. I'm tired of hearing this. There's often a connection between this kind of embezzlement and in the last lady's case and childhood trauma. And I don't know whether that's the circumstance here. Many of the embezzlers were female. I tried, and Ms. Garrity's right, they can be very tedious. I tried a number of cases as prosecutor. And, but a competent auditor can really show a lot. Anyway, that's an important component of this, and I want you to be forthright in there. It fell out of favor. The circuit court quit using it, which was a great disappointment to me. But we still have it available, and we've got several people in the pipeline. So I want you to take this form downstairs to the probation department. They'll get you started on the terms of this probation. I wish you luck.
Your Honor,
Yes?
if I may just elaborate on your comments about the embezzlement court, I think treatment. This is the first I've heard of it, and I know a lot of, I'm all over the counties in the state, and I know a lot don't offer these kind of programs, but I believe, and I believe the court will agree, that people that steal or take what's not theirs are having some issue with their own self-worth and integrity, because that is a very slippery slope. Once you start doing something that you know is not right, it makes you internally believe that you yourself are not right, and you continue to engage in that behavior. So I want to thank you for pushing that, because I think it does far more rehabilitation than regular probation or incarceration.
Well, there's a lot of shame and guilt and sleepless nights and worrying for when the hammer's gonna fall. And there's more to it than someone that just steals a bottle of liquor off a shelf. And so thank you for that. Anyway, Ms. Barajas, I wish you the best. You go down to probation and we'll get you started, but you do owe me 30 days of jail.
Yes, Your Honor. Thank you.